It is September 16th, 2021. It is 9:19 a.m. and this is a regularly scheduled meeting of the Oil Conservation Commission. I am Adrienne Sandoval. I am Chair of the Oil Conservation Commission and Director of the Oil Conservation Division. Also with me today are the two other commissioners. Would you please introduce yourselves for the record?
Good morning. I'm Greg Bloom. I'm the designee of the Commissioner of Public Lands, Stephanie Garcia-Richard. Thank you.
Good morning, Terry Warnell, designee for EMNRD.
Thank you. Also with us today is Chris Moander, who is counsel to the commission, and Florine Davidson, who is commission clerk. Oh, I just lost my place on the agenda here. All right, first item of today is approval of the agenda. I'm going to note actually quite a few things on here. Agenda item number 4, de novo case number 21744, has been continued until I believe the next docket in October. Case or agenda items number 5, 6, 7, and 8. Those were settled and removed off of the agenda. Agenda item number 9 still is retained on the agenda for today and will be the only matter that we are hearing, as well as the remaining agenda items 10, 11, 12, and 13. So with those changes, is there a motion to adopt the agenda?
Madam Chair, I move to adopt the agenda.
Is there a second?
And Madam Chair, I second that motion.
Great, thank you. Mr. Moander, would you please do a roll call vote?
Yes, Madam Chair. Commissioner Bloom?
Yes.
Commissioner Warnell?
Yes.
And Madam Chair?
Yes.
The motion passes.
It looks like we're having the lawyer from the land office can't participate. Let's go through the next agenda item and then I'll try to work on seeing if we can get your settings working. Agenda item number 3, approval of the August 12th, 2021 and August 27th, 2021 meeting minutes. Commissioners, have you reviewed the minutes and is there a motion for approval?
Madam Chair, I have reviewed the minutes and I would move to approve the minutes from our last meeting.
Madam Chair, I second that motion.
Just to confirm, Commissioner Bloom, you said the last meeting. Do you mean both the August 12th and 27th minutes?
That is correct. Yes, thank you.
Okay. And just to confirm, Mr. Warnell, is that for your second of the motion as well?
Yes, I second that motion.
Thank you. Mr. Moander, would you do a roll call vote, please?
Yes, Madam Chair. Commissioner Bloom?
Approve.
Commissioner Warnell?
Approved.
Madam Chair?
Approved.
The motion carries.
Thank you. All right, let me see if I can. I'm sorry if I'm going to say your last name right, Mr. Kalunsich. I'm sorry, that's probably very wrong. You have like 3 things. I see you 3 different times. I can try to move the other 2 entries over to a panelist and then see if you can I moved all of your entries over to panelists, so hopefully you should be able to either mute or unmute one of them and speak. Can we test that out? Ooh. There's a lot of, I heard something, but there's a lot of background noise. Same thing.
Yes, Mr. Glinsett, you might try and see if there are any other WebEx open and close those out. Or if you would unmute, perhaps the chair can terminate the other two
There are
appearances.
two that are unmuted. Okay, I can't hear anything if you're trying to say something.
Can anyone hear me at all?
Yes, I can hear you now, but there's a lot of feedback.
All right, I'm gonna go ahead and endeavor to play some of this. And maybe stars with alignment and will work. Can people hear me now?
Oh, that's better. I kicked one of your profiles out.
Okay, I regret the challenges here. We've, yeah, I don't know. It appears that people can hear me. That's going to meet the requirements for the basic rules of parliamentary procedure. And I guess we can go forward.
Okay. All right. I think I think we're good now. Let's hope so at least. Are the remaining parties on here that we can as panelists? I think so. Chris, do you see any who are missing? I don't want to have to like go back in the middle of this.
Madam Chair,
Yep, go ahead.
this is Sharon Shaheen on behalf of Titus. I just note that we have a Titus representative who's joined through the agenda link.
Okay.
And if you have any questions for him today, then you may need to make him a panelist as well.
Okay. All right, we can do that if we get to that point.
Okie doke. Thank you.
All right. Well, with that, let's go ahead and jump to agenda item number 9. This is let's see, in a case number 21872, which is an application of Titus Oil and Gas Production for approval of production allocation. We will be doing basically a status conference today. This case was heard in front of the division, and all of that information appears to have been sent up to the commission, so thank you. I think we will start. Ms. Shaheen, if you would like to introduce yourself and your client, and then we can go through the other parties. And then we will provide each person an opportunity to speak.
And Madam Chair, if you permit me, I'm going to recuse myself from this case, and Mr. Esteban Baca, the Director of Royalty Management Division, will take my place as a designee of the Commissioner of Public Lands.
Okay, thank
Thank you.
you. And with that, Commissioner Bloom will be leaving us. And Mr. Baca, can we hear you?
Good morning, Madam Chair. Can you hear me?
Yes,
Yay.
fantastic. All right, now, Ms. Shaheen, would you like to introduce yourself and your client briefly? And then we
Thank
will
you,
go through the
Madam Chair.
parties.
Yes, thank you. Good morning, everyone. Sharon Shaheen on behalf of the applicant Titus Oil and Gas Production LLC. Also with me today is Walt Jones. He is, I believe he's Vice President of Land with Titus.
Thank you. Is there, I think, Jesse, a representative from the division?
Yes, Madam Chair. My name is Jesse Tremaine. I'm counsel for the Oil Conservation Division.
Thank you. Let's see, Mr. Feldewert.
Good morning, Madam Chair, members of the commission. Michael Feldewert with Santa Fe Office of Holland and Hart, appearing on behalf of EOG Resources, Inc.
Thank you. Am I correct that there's also the land office as a party?
At this point, no, Madam Chair, I don't believe there's been an entry or an attempt to put an entry in that I'm aware of.
All
Good
right.
morning. Can people hear my voice?
Yes.
Good morning, Madam Chair, panelists and participants. This is Nicholas Collins, appearing on behalf of the Mexican State Land Office. I appreciate the opportunity to be heard. I'm sorry about the technical difficulties here, but we wanted to chime in our position on this matter.
Mr. Kolumsich, could I ask who you said you represent? It faded out a bit.
I can barely hear you, but I think you asked who we represent, the Mexico State Land Office.
Thank you.
No, thank you.
Mr. Moander, just to confirm, was there an entry of appearance on behalf of the State Land Office?
I did not see one. I last looked at the file about 2 o'clock yesterday. I can certainly take another look if you'd like, Madam Chair.
Okay. All right.
I know Nicholas Collins is speaking. I can represent that I have yet to file a written entry of appearance. Is it permissible to do an oral motion to appear or oral notice?
Mr. Moander.
The rules, I'd have to look at the rules on this because I don't think there's anything that says one way or the other about that. I could take a look. I'm going to still request that one be submitted in writing. If you'll give me just a second, I'll spot check the rules.
No, we'll be happy to go ahead and enter a written one thereafter.
Okay.
If it gives anyone any comfort, the Mexico State Land Office doesn't intend to soapbox here.
Okay, well, Mr. Moander, while you're confirming that, why don't we go ahead and move forward? All right, Ms. Shaheen, we have, keeping in mind that the commission has reviewed the records that have been provided, would you like to provide a status update for the commission, please?
I'm happy to. I believe Ms. Hardy is here to enter an appearance as well on behalf of Pegasus.
Okay,
That's correct.
thank you,
Morning.
Ms. Hardy.
Yes, good morning. Dana Hardy with the Santa Fe Office of Hinkle Shaner on behalf of Pegasus Resources LLC, Fortis Minerals 2 LLC, and Santa Elena Minerals 4 LP. Thank you.
All right, thank you. just to confirm, did you send in an entry of appearance?
Yes, Madam Chair, we did file one.
All right. Go ahead, Ms. Oh, sorry. What, Mr. Moinder?
I didn't realize I'm unmuted. I'm yelling or like raging at my computer at the moment, so I apologize.
Great. Okay. That's all right. We understand that. I think everybody here at this point. Now, Ms. Shaheen, would you like to begin? Thank you.
Yes, thank you. I thought it might be helpful just to talk briefly about the procedural posture of this case, because as everyone knows, this was not a request for de novo review by the commission. Rather, there was an order entered by the director who referred this to the commission under section 70-2-6B and 19.15.4.20B in MAC. And those are very simple rules in a statute. 70-2-6B says any hearing on any matter may be held before the commission if the division director determines that the commission shall hear the matter. And the reg provides the hearing on a matter shall be held before the commission if the director directs the commission to hear the matter. So under those circumstances, since we did present all of our evidence below to the division, I'm wondering whether there is a need for another evidentiary hearing. So I just wanted to put that out there. I spoke with Mr. Moander yesterday and then had this revelation early this morning that maybe there is no need for an evidentiary hearing. So I'll just put that out there. If the commission feels there is a need for another hearing, Titus would ask that a special hearing date be set. And that is because these this well is on the imminent drilling schedule. And as the commission is well aware, moving rigs around, changing a schedule like that is very costly. And frankly, Titus needs to know by October 1 whether or not it can drill this well into Texas. So if you have any questions about that, I'm happy to help there, or Mr. Jones could probably weigh in as well if you have questions for him. So this, would it be possible for me to share my screen?
Yep, let me give you permission.
And Madam Chair, I'm going to put on the record here under 1915-411 NMAC or 411B NMAC, a party may enter an appearance by oral appearance on the record at the hearing that is the party wishes to be a party to. So the oral motion is acceptable. I'd always encourage a written one for the integrity of the record.
You'll have it.
Thank you for confirming that. And just for my help, can you pronounce your last name again so I don't mess it up, please?
Oh, Madam Chair, panelists, it's my pleasure. It's Nicholas Collinsich.
Collinsich. Okay.
There's no apology necessary. I've had time to get used to it being mispronounced. If people like, they can just call me Nick.
Okay, thank you. All right, thank you, Ms. Shaheen. I think for the commissioners, let's go through all of the parties and then direct questions as necessary to any of the council, or if we need additional technical testimony from Titus's witness. All right, Mr. Tremaine, would you like to make any statements on behalf of the division?
Thank you, Madam Chair. The Oil Conservation Division's position is that this case represents unique and novel legal and technical issues, which I won't get into in detail here. But ultimately, the OCD believes that prior to issuance of any order in this matter that memorandum of understanding is necessary between the states of New Mexico and Texas. We cannot identify enumerated authority for the OCC to issue an order that would effectively dictate an agreement related to allocation and other issues between New Mexico and Texas, or any other state for that matter. The OCD also believes that this context, this factual situation is likely to be repeated in the future. And so this particular well, while we understand the proposed drilling schedule for Titus, should not be handled in isolation, and that the MOU and a negotiated MOU between New Mexico and Texas is necessary as the framework for an order that OCC would issue. We do see a couple different alternatives going forward, and one is to continue this matter until such time as a lawful MOU is executed between New Mexico and Texas. And I want to point out that that does not necessarily mean that an order would look radically different from the current proposal or other orders, but that has yet to be negotiated between the states. And the second alternative is to proceed to hearing, and I would concur with what I understood Ms. Shaheen's sentiment to be that it is not necessary to conduct an entirely new evidentiary hearing, that if this does go to a hearing date, a special hearing, that the OCC's review of the matter, I would recommend be primarily based on the record below, along with any other supplemental findings. The OCD would be taking the position in that case that an OCC order approving the application be made contingent upon the execution of an MOU between New Mexico and Texas. Thank you.
Thank you, Mr. Tremaine. Mr. Feldewart.
Madam Chair, members of the commission, EOG has nothing.
Okay. All right. Hopefully I don't mess this up. Mr. Koloncic.
Thank you much. Thank you very much, Madam Chair. Nicholas Collins on behalf of the New Mexico State Land Office. The NMSLO concurs with Mr. Tremaine's position. Written agreement of some kind between Texas and New Mexico is necessary, and from our perspective, I would argue it's objectively desirable. The advantages to this approach would be as follows: minimize the instances of inevitable future controversies. It'll conserve litigation and administrative resources down the road. This will be replicated in the future, such that putting in a little bit of time now to get it right will probably spare all of us time and expense down the road. And I can further represent that the New Mexico State Land Office is committed to moving forward with it relatively quickly. The perspective is that the NMSLO wants to be an active participant in whatever's drafted, so that we can make sure that we can optimize the beneficiary's position. In the past, from what I was able to review of the record that was submitted both here in Texas, we seem to be largely in agreement. Mexico jurisdiction, bonding is a solution for any possible plugging problems, and then more granular specific deal points like allocation, reporting requirements, financial assurance, permitting, environmental issues like air and releases, notices, inspections, plugging, abandonment. We could address all those issues now on the front side, or we could wait until they become much bigger problems down the road. So That is the New Mexico State Land Office's position, and I would like to repeat that we have a shared interest in making this happen on the applicant's timeline, if at all possible. We just want to participate in the process. Unless anyone has any questions for me, I'll stop talking.
Mr. Can I interrupt for just a moment?
Of course.
I'm having trouble hearing Mr. Kalumsic.
Nicholas, yeah.
Nicholas, sorry.
Not at
So
all.
I'm going to make a little adjustment here so that I might be able to hear better. Okay, let me try that and see if I can hear him better.
Is that any better for you?
Testing. 1, 2, 3, 4. Is that better, ma'am?
A little bit. Yeah, thank you.
Okay, I don't want to make your job any harder than it is. Is it helpful if I repeat myself, or?
No, right now it sounds good. Did you move a little closer to your microphone?
No.
Okay, because it kind of fades in and out a little bit. Is anyone else getting that?
A little bit, but
Yeah,
it sounds pretty clear right now.
okay.
Again, Ms. Morganbeck, I'm happy to go ahead and repeat the points that I made before, because I don't want you to have to
Sure,
spend
yeah,
hours
we're
trying to
great for
decipher
sure.
garbled speech.
Yes, go right ahead. Thank you.
Okay, just to review, thanks very much for their time. The New Mexico State Land Office doesn't have any vociferous opposition to this project. A review of the record provided to date informs that we're largely in alignment with Titus on this matter. New Mexico jurisdiction, bonding, specific deal points such as allocation, reporting, financial assurance, permitting, environmental issues, notice, inspection, plugging, abandonment. All of this appears in the record, and the New Mexico State Land Office stands poised to assist in getting this done relatively quickly to optimize revenues for everyone, you and our beneficiaries. Unless anyone has anything further, I'll stop talking.
Thank you.
No,
Ms.
thank you,
Hardy?
Madam Chair.
Oh, no problem. Ms. Hardy, would you like to say anything?
Just briefly, thank you, Madam Chair. Pegasus, Fortis, and Santa Elena have submitted a brief in support of Titus's application in this case and would like to see the application approved. They have an interest in the well. And so that's our position, and we concur with Titus and Ms. Shaheen. Thank you.
Thank you. Commissioners, do you have any questions for any of the parties at this time?
Madam Chair, no questions from me at this time.
I can't hear you, Mr. Warnell. You look muted though, so don't panic.
I am muted. Sorry.
Okay,
about
good.
that. Okay. Madam Chair, I share the concerns of the State Land Office and of OCD. My biggest concern looking through this material last night was the allocations between the states. I didn't see anything on that, and that seems like it should be a high priority. I'd like to see that. Other than that, I'm ready to proceed.
Okay, I have a couple questions. Mr. Tremaine, is there a status that you can provide the commission on the MOU?
Yes, Madam Chair, there is a draft MOU. actually my predecessor in this matter has had ongoing contact with the parties, particularly Ms. Shaheen, but in reference to the MOU, has been in contact with the Bureau of Land Management and the Railroad Commission in Texas. Our point of contact with the Railroad Commission in Texas has changed. So there will be some work necessary to move that forward from the stage it is in, but it is in a draft stage, and the parties are, well, the Oil Conservation Division is ready to work with the State Land Office and continue negotiations with the Railroad Commission in Texas.
Do you have any idea how long that could take? I imagine there are quite a few issues to probably work through.
I think there are a number of issues. I haven't had the benefit of speaking directly with the State Land Office on this matter, so I think that's the next step. I don't want to guess. I would suggest it's in the order of weeks rather than days.
Okay, thank you. Ms. Shaheen, does your client intend to drill more wells that have this same scenario, being kind of cross-border?
Yes, that is correct. They do have a development plan that covers more than is presented in this particular application. If I may, if that answers your question, I believe there's an exhibit attached to the affidavit of Mr. Jones that talks a little bit about the development plan overall. And so I just, if I might be able to address some of the points that counsel for the division and for the State Land Office made, it might help me at least focus my presentation. So first I would note that this well, like I said, is on the drilling schedule now. And we appreciate the State Land Office indicating that it supports the drilling. And we understand that the division and the State Land Office believe there's a need for an MOU. I think what we're wondering if it's possible for us to do what I believe someone suggested earlier, which is to enter an order contingent on having an MOU in place, contingent on production not occurring until December and having an MOU in place. That way we would be able to drill this particular well, and otherwise the acreage in Texas will be stranded because it's highly unlikely that anyone would be drilling a vertical well in that 40 acres or so that is in Texas. As far as, frankly, I know that Mr. Moander suggested that there are inevitable future controversies. I think that might be more related to wells that would be drilled from Texas into New Mexico. Here, Titus is only asking to drill from New Mexico into Texas. And we believe there's no need for an MOU that addresses drilling from Texas to New Mexico at this time. If somebody later on, another operator wants to come along and drill from Texas into New Mexico, then they can come to the division and the commission and ask for that. But here we're simply asking to be able to drill from New Mexico into Texas, and we believe the MOU should address that circumstance only. And we think that would help alleviate the concern about any possible future controversies. With respect to Mr. Warnell's, my client is reminding me that Texas has already approved this this permit. That permit has been issued, and Titus has full approval to drill into Texas. So Mr. Warnell asked about the allocation between the states, and that is really the sole purpose of the application. I'll back up just a little bit. Titus began working on this project back almost a year ago, and first began conferring with the division, I believe, February, March, and was instructed that Titus would need to file an application for approval of production of allocation. So that is addressed in Mr. Jones' affidavit below, and it's very simple. And Texas has approved this proposal. Titus proposes to allocate to New Mexico and to Texas based on their proportionate share of the acreage. And the alternative, they could also do it with respect to, you know, I'm going to have to look. There was an alternative. So New Mexico, my understanding is New Mexico historically has allocated production based on acreage, and Texas has historically allocated production based on completed lateral length. And so we have those two alternatives, and Texas, the Texas permit and approval indicates that it's open to either one. And in this particular instance, the interests that go to New Mexico and the interests that go to Texas are about the same, regardless of whether it's based on acreage or completed lateral. So that's addressed in Mr. Jones' affidavit, and also, I believe, in the transcripts below. And it's also addressed in the order that was issued by Texas and the permit. Just taking a quick look here. I know that Mr. Tremaine mentioned that there's nothing that, there's no authority that allows New Mexico to allocate production between the states. And I would only point out that there's nothing that precludes the division from exercising its authority to approve the allocation of production that we're proposing with respect to New Mexico. So Texas has already approved the allocation of production with respect to Texas. And all we need now is for the division to approve the allocation of production to New Mexico. And I believe it's pretty clear that the commission and the division have authority to do that. Just give me a second here to run through my notes, make sure I haven't forgotten anything I wanted to address. So then I did have a question. I think you asked the division attorney the question of how long would it take to put together an MOU. So if anyone else has any insight on that, for example, once an MOU has been drafted, how much time it would take before the division or the commission or whomever is a party to that agreement needs to approve it, that would be helpful for us to know. As for, there was a comment that this presents unique and novel technical issues. Frankly, I don't think that there are any unique technical issues here. It's the same formation. Nothing changes. There's nothing unique about the drilling of the well or production from the well. The only thing that is unique is that it crosses the interstate line. So it seems to me the real issues are simply reporting issues and regulatory compliance issues. Titus, of course, is bonded in both states, is ready and willing, and will comply with the requirements of both states. Texas has already indicated how it wants reporting to occur in Texas. I think it would be just a very simple method of instructing Titus as to how New Mexico would like for production to be reported. And I believe so. For example, in Texas, production is being reported on Texas production, and then in a separate box on the form, they indicate total production. There are 2 API numbers for the well. We already have a federal permit from BLM for this well, and we've been told that the only change that needs to be made with respect to that federal permit is to submit a sundry indicating that it would be a longer well than is currently permitted. So all reporting would be done with respect to each of the 2 API numbers, one to the New Mexico API number and the other to the Texas API number. So I think that covers most of my comments. I wanted to also note that there is a joint operating agreement with the sole working interest owner in Texas, which is OCC. So if you think it would be helpful, I'm happy to walk through the packages that we have. They've been bookmarked, and I can show everyone where they can find the information that they believe is important to know. And I stand ready to answer any other questions you might have.
Thank you, Ms.
Madam Chair,
Shaheen.
this is Jesse Tremaine. If I could really briefly respond.
Yeah, I'm going to give all of the parties an opportunity to respond. And then Ms. Shaheen, I'll come back to you. Mr. Tremaine, would you like to go ahead?
Sure, just a couple points really briefly. One, I take Ms. Shaheen's point about the my earlier phrasing with the technical issues. Primarily, the OCD is concerned with potential or probable conflict between the laws and regulations in New Mexico and Texas. And some of those issues are reasonably foreseeable and inconsistent between the states. The OCD's position is that the direction of the lateral doesn't matter. Many of the issues are going to exist regardless of the surface hole location, whether that's in New Mexico or Texas. The allocation issues are the same. And I wanted to clarify in setting out the alternatives earlier, OCD's preference and recommendation is that this matter be continued until the MOU is in place. I think that will allow the OCC to make a more informed decision and order. And while as a general matter, this project is not objected to by the OCD, the alternative that I've outlined of proceeding to hearing and issuing an order making this contingent upon the MOU is an alternative. It's not OCD's preferred alternative, and that would be our suggestion if the commission were inclined to hear this. And lastly, the issue in terms of the timing of the MOU. To clarify, when I said weeks, I don't want to guess as to the number of weeks, but our current projection is not that this would be executed in advance of the currently proposed drilling schedule. We're not looking at early October. We're looking later October or potentially later in the fall. There's a lot of interested parties that will be looking at this. We need to incorporate not only the State Land Office, but the Bureau of Land Management. And I think as we move through this, there's going to be a number of other interested agencies that we need to at least consult with as a threshold matter, even if they're not taking as active of a role as OCD and the State Land Office. And that's all. Thank you.
Thank you. Mr. Feldwart.
Madam Chair, members of the commission, I have no questions or statements to make at this time.
Thank you. Mr. Klonsich.
Thank you very much. The New Mexico State Land Office is comfortably here and gratified to report that we appear to be in agreement with much of what was said by both the applicant and by Mr. Tremaine. We think it is probably best to go ahead and have a thoroughly written and firm document stipulated and agreed to before there's a formal ruling on this. Another matter that I jotted down swiftly as he was speaking was a practical one, just in COVID times. One that I don't think we belabor here. Regrettably, anything that requires collaboration in COVID times seems to be taking a little bit longer. I find that the matters I can do individually go quicker, but things just seem to take longer. I've learned only now that we think it may take a little bit longer than we're hoping, but I approve of the idea of goal setting to try and get these matters decided for, I don't know, excuse me, get the MOU or more accurately some sort of written contract by December, with the provision that if there's good cause for an extension of that timeline, that we at least have that option. Unfortunately, it looks like the COVID numbers are going up, and I just don't. There's just a lot. There are a lot of question marks hanging over this. Now, the desire for a firm and enforceable written contract of some kind is needed. About this, we seem to agree. We do not want to kick the can down the road for future controversies by at least considering cross-border issues. The matters of jurisdiction, potential spills, potential releases. We'll want to at least consider those matters in forming those. Now, I also agree with Titus's representation with respect to bonding. That's an important issue that we would need to resolve before we can really nail down or look for an order from the commission authorizing this project. We want to have some certainty as to what we're doing. The final point here is that goal setting is always a desirable goal. I find that sort of motivates and pushes participants and stakeholders to prioritize things with a deadline. But to repeat, I believe that because this allocations thing is a new and novel thing, subject to possibly being repeated in the future, it's worth putting some time in and it's worth doing right. If I may have one more minute to review my note. The New Mexico State Land Office has nothing further. If there are any questions, we stand happy to answer them. Thank you.
Thank you. Ms. Hardy?
Thank you, Madam Chair and Commissioners. We concur with Titus, and I don't have any other comments to add. Thank you.
Okay. Commissioners, do you have any additional questions?
Madam Chair, I do have one question for Ms. Sheehan. The drill date of October 1st, I want to say I read it in the hearing notes that were there. Is that to maintain a state lease that if no action was taken on that, it could be possibly lost?
I am not aware of any potential lease terminations here.
Okay.
Yes.
So do you have any idea why that October 1st was chosen just part of the drilling schedule?
It is part of the drilling schedule. It's been on the drilling. Actually, it was on the earlier drilling schedule, but this it has been moved around. The drilling schedule has been changed, but at this point, Titus is committed to drilling that well. It will be drilled. Now, whether it will be drilled into Texas, which would allow additional, which would prevent waste by allowing additional production, would be dependent on the timing of an order on this application. And I would just reiterate that Titus would request that an order be entered now, contingent on the finalizing of an MOU that all of the parties agree to. And I'm encouraged by Mr. Tremaine's estimate that an MOU could be completed later in the fall. And in light of that information, I believe that it is feasible to consider the alternative that's proposed by the division, which is to enter an order now approving the application for production allocation, contingent, having production contingent on having an MOU completed by December, sometime in December. With respect to the bond issue that was raised, I don't think there is an issue there. Titus is compliant with the bond requirements in both Texas and New Mexico already. It's an operator in both states, so that should not be an issue. With respect to other interested agencies, respectfully, I would note that.
Sorry to interrupt you, Ms. Shaheen, but can we just at this point stick to the commissioner's questions, and I will give you an opportunity at the end to address any of the comments from the other parties.
Absolutely. My apologies for running off in a different tangent.
Mr. Baca, did you have any other questions?
Madam Chair, I do not.
Okay, thank you. Mr. Warnow? I think you're muted.
No questions at this time.
Okay. I'm not sure exactly who to direct this question to, but either the division or Ms. Shaheen. Has BLM said anything regarding this? Have any concerns, questions, etc.?
Not to my knowledge. As I mentioned earlier, we already have a permit from BLM and have been informed that the only thing that needs to be done if we are drilling the well into Texas is to file a sundry notice.
Do you know what the application processing time on that is?
I don't think there's much of a processing time. It's just a matter of filing the sundry notice.
Okay.
My client is telling me a couple of weeks.
So I think you mentioned that you're basically planning to drill the well regardless of the MOU. It's just an issue as to, do you stop it at the New Mexico border, or do you drill it into Texas? Would you be drilling on October 1st regardless? Like, is that the plan? Like, it's on the drilling schedule. October 1st is it. We either drill it to the border or we drill it over the border, depending on where we're at.
And that may be a question that I need to confer with my client on, but I understand that they are going to drill the well. And the question is whether they will stop at the appropriate, within the standard setbacks, or whether they will continue to drill into Texas. I don't know if that answered your question. Maybe I need to hear it again. My apologies.
I guess my question is, you basically said like it's on the October 1st drilling schedule. Is it going to be drilled regardless on October 1st? And it's a decision point of how long it is? Is it stopping at the border or is it going across the border?
I think that's the decision point. And I need to correct a misstatement that I made earlier. I understand there is a state land office lease that will be expiring if we don't drill. And so that is why they are drilling one way or another, because there is a state land office lease that would be otherwise expiring. So I think October 1 is the decision point date. And they may have already spud this well, frankly. I don't know, and I may get some information here any minute, but the state land office lease expires the end of October. So they will be drilling in October to prevent expiration of that lease. And October 1st, I understand, is the date of the decision point as to whether they're going to stop and only drill in New Mexico, or whether they will continue to drill into Texas. That's my understanding. I'm getting information as we speak, so.
Okay. So that sort of answers my next question, I think. And maybe a question for the State Land Office. Are there opportunities to extend that lease if there's like pending MOU negotiations?
Thank you, Madam Chair, Commissioners, Mexico State Land Office again. I was not prepared, and the record here seems to be a little unclear as to the as to lease expiration. Thus, the State Land Office can't make any representations or promises other than that I can represent and promise that as soon as I conclude this hearing, I'll check with the boots on the ground oil and gas people to see if they to see if we're authorized under law to do some sort of extension. It is my recollection that we are, but it's not for me to do some sort of ad hoc promise if I don't know that to be the case.
Thank you.
No, thank you.
Madam Chair, I do have a little more information. If you would like for me to provide it to you. Titus is currently drilling a 4-well pad, one of which is this well, the El Campeon 404H. It's pad drilling, so they'll be drilling portions of each lease vertical, then horizontals of each well. And that is how they've started the drilling, but still have time to make a decision as to the length of the lateral for the El Campeon 404H.
Thank you. Sorry, 2 seconds. They're drilling and it's very hard to hear. Okay, there's a break. So on that note, Ms. Shaheen, if there, I guess I'm trying to understand, is there going to be waste, not on the Texas side, on the New Mexico side, if this well is not drilled in that October timeframe, because you won't be able to go back and add this additional well later due to like, potential spacing on the well pad, being able to get a rig in there, whatever it may be. If this sort of kind of October date is not met, or is it just this is the ideal time frame to do it because it's on the drilling schedule and it costs money to move? Those are two very different things. Can you clarify?
I'm sorry, could you, I got the last part of it, of your question, but I'm not sure I'm clear on the first part of your question.
It sounds like you've already started drilling on that. It's a 4-well pad, right? Correct? Are the other wells, okay, let me do this in parts. Are the other wells on that pad, they're not going across the border, correct?
Correct.
Okay. So you started drilling on the pad. The other wells aren't going across the border. This is the only one that's going across the border, correct?
That's my understanding, yes.
Okay. So if you do not drill this well in the October timeframe, are you going to not be able to go back to that site and basically add this well in later due to maybe spacing issues on the site, like logistical problems? So you would end up with a 3-well pad instead of a 4-well pad because you can't get a rig on site later due to like spacing and logistical problems. I'm trying to figure out if that is the issue with this October timeframe, or it's more of an issue. Maybe start with that. Sorry.
My understanding is there are surface issues here which require them to drill all 4 wells at this time.
That is okay. That is what I'm trying to figure out. So there are surface issues on the site that if you do not drill sort of the one well after another, you're going to be, will you be stranding that entire acreage?
Now, it's possible with respect to that formation. I'm not sure about the answer to that question, But I understand that there would be new federal permitting and there would be drilling next to producing wells. And these are all issues that require them to drill all 4 wells now.
Okay. And so then it will be a question of, because you have to drill all 4 wells now because of spacing problems and surface issues, or more surface issues, then the question becomes, do you drill it to the border or do you go across the border, correct?
That's right.
But you've got to drill it in October. Correct?
That's correct.
Okay. Okay, that is helpful. Just trying to understand those pieces. All right, I have no further questions at this time. Ms. Shaheen, I'm sorry if you can hear that. I'll let you address or finish up with any additional statements before I go to the commissioners.
Going back to the mention of the bond issue, as I noted, Titus is fully bonded in both New Mexico and Texas, and so I don't believe there's an issue there. With respect to other interested agencies, all of these agencies were noticed. They received the notice letter for this application. That includes BLM, the State Land Office, Tax and Rev, the Texas Railroad Commission, and the corresponding agencies there in Texas. All of these agencies received notice of the application and none of them entered an appearance. I don't, and after conferring with BLM, Titus's understanding is there's not a big concern there. So I don't think it's going to be a huge problem to get an MOU ready with respect to those agencies. There was a concern about differences between regulations in New Mexico and in Texas. Mr. Tremaine, if I understood his comments correctly, he believes that the direction of the lateral doesn't matter. With all due respect, I think it does matter, and that is because Titus will be regulated with respect to, will be under New Mexico regulations because the surface hole is going to be in New Mexico. So it will be required to be compliant with all New Mexico regulations that apply to any well that's drilled in New Mexico. So if the MOU only addresses the New Mexico to the Texas, into Texas drilling, then you avoid those regulatory issues that Mr. Tremaine referenced. So again, I'll just follow up. We would request the alternative proposal that Mr. Tremaine offered, which was to enter an order allowing the drilling into Texas contingent on a fully drafted and executed MOU by December or in December.
Thank you.
Madam Chair, I've got a question I'd like to ask, if I may.
Go ahead.
So I'm trying to summarize kind of what I'm hearing today, because this is, it sounds like there's no, at this point, inherent, or there's no opposition to Titus's proposal, save for the issue of the MOU. Is that a fair and accurate understanding on my part? And anyone can answer. I mean, everyone can answer if they want.
Thank you for your question, Mr. Winder. It's Nicholas again from the New Mexico State Land Office. The New Mexico State Land Office has no opposition to this project on condition that we're there and are in a position to have our voice heard with respect to the practicalities of this matter. I'm very interested in how such things as this have been done in other jurisdictions. Is an MOU a legally binding document? is that established practice when we have somewhat novel or unusual drilling setups. But the New Mexico State Land Office is committed to helping this project go through, so long as our concerns are addressed in some form of written contract.
Mr. Moender, this is Jesse Tremaine for OCD. I agree that there is not any inherent objection to the project itself. Our concerns have to do with the timing and the lack of an agreement between Texas and New Mexico. And I don't have any reason to foresee in particular issues in getting to an MOU other than the process. The issues that are brought up about that process. It's just that it takes time.
Thank you, gentlemen. I do have a follow-up, and this is for SLO's counsel. So just to clarify, it's the land office's their land office is interested in just being heard about any of Titus's proposals, which to me sounds like the land office wants to proceed to a full hearing on this matter. Is that a fair understanding?
I can't represent if that's necessary at this time. I just don't know if we need an order from this commission until we have an MOU, which actually explains what the rights are.
If I may, Madam Chair, I would like to make one response to Mr. Moander's comment earlier about other interstate wells.
See.
I'm sorry.
Oh, I'm sorry. You can proceed. Go ahead.
Thank you. In the second status report that was submitted on September 1st, Mr. Jones talks about his communications with West Virginia and Pennsylvania. There are some interstate wells in that part of the region because there are 4 states come together there. And so there is no memorandum of understanding between, I believe it's Pennsylvania and West Virginia. Instead, I believe one of the states permits the well, and then the other state has an MOU with the operator. And that spells out the understanding. Now that is another alternative. I'm sure that Titus would be willing to execute an MOU directly with the division with respect to this particular well, while the parties move forward getting the more complete MOU.
Thank you. Mr. Moender, do you have any more questions?
No, Madam Chair. Thank you.
All right. At this point, I think that there are a couple questions before the commission. One, do we feel like we need a full evidentiary hearing on this? And 2, sort of just, well, I guess in general, how to proceed and what pieces we need in place. Mr. Moiner, what's the mechanism for this? Could the commission issue an order out of this hearing, sort of either directing the parties to do X, Y, and Z, or an evidentiary hearing, or an MOU, or sort of, could you walk me through like what the mechanisms here are?
Well, so I've taken a look at this, and so the issue is on the lack of opposition, or whether the petition is unopposed. In this case, we've got, I think, 2 issues that kind of cloud this a bit, because in one instance, through the division, if they're asking for or they're seeking the MOU, and please pardon my new puppy, he's being a bit of a brat this morning, so Here,
Awesome.
pardon me for 1 second. I'm going to
What's
take
your
care of
dog's
this.
name?
No problem.
This is Dutch, and Dutch is a 1-year-old pitty mix, and he's being a real pill. So 1
He's
second,
very
please.
cute.
That's the problem, right? Like, come on, out of
The
here,
best thing about working from home.
out of here. Come on, he's not. Okay, so the issue is, it's if there's an issue with presenting the MOU as effectively a contingency in an order, which I think that's a fair description here, is that the order would lack effect if the MOU is not entered. I think that could be construed as it's an opposition, not necessarily to substance, but to procedure. And then with the state land office, it isn't clear to me that they, I mean, and correct me if I'm wrong, but it sounds like to me there's a desire to at least proceed with the hearing so that there's an opportunity for the land office to be heard, which I think also puts in what could be viewed as an opposition, maybe not to substance, but again, in terms of procedure. So this is a tough situation because I don't think the parties actually have an issue with Titus's proposal at its core, but with the two situations outlined, it would seem to me we'd have to proceed at least to some extent, unless we can get some sort of agreement or stipulation universally here, and I have my doubts, kind of given what I've heard today. So, and you know, that I think is the big issue, because the rules refer to unopposed pooling applications, but I think up to this point it's been pretty clear that there has been opposition of some kind, and I think that's enough to meet the standard of opposition.
And by move forward, do you mean move forward to an evidentiary hearing?
Correct.
Okay.
May I respond, Madam Chair?
Briefly.
And really, it's more of a clarification, because what I understood, Mr. Kolinsich, I'm going to try pronouncing it, to be saying is that they want a seat at the table in negotiating the MOU. I didn't understand him to be saying that they believed that there needed to be an evidentiary hearing. I could be wrong, and Nick, please correct me, but that was my understanding.
Yeah,
Go ahead and address that.
May I communicate the NMSLO's new information?
Yes, please.
I was only informed a moment ago via the email that evidently an extension was offered to Titus. Nothing's been entered. I don't know if, what the status of the response is, but whatever it is, an extension was offered. Our position is that we need to be at the I don't know, we need to be at the table with respect to whatever agreement is written. Again, I'm not 100% certain that memorandum of understanding is sufficient. My preliminary research informs that may not be as robust a contract as something that's officially, I don't know, as other titled documents.
Mr. Kolinsich, you're fading out a bit. Could I have you restate the last couple of sentences you said?
Yes, Ms. Morganbeck. The New Mexico State Land Office reports that there is an extension was offered. We also want to reemphasize that New Mexico State Land Office needs a memorandum of understanding, participate in the drafting of that contract, be it called an MOU or something else. I also am persuaded by what's been heard here that perhaps we do need an evidentiary hearing down the road, and I'll tell you why. If we're able to come up with something that's acceptable to all of us, we vacate the hearing. We have it on calendar. We have another motivation, another form of goal setting for us to get things done in the interim.
So, Madam Chair, I think I mean, unless the parties have anything additional, I'm just going to, for purposes of clarity, NMAC 1915-412, let me check this, D, I believe, or wait, hold on. A1D allows, this it talks about the division, but if an application is unopposed, and the record is complete based on the division of the commission's interpretation, an order can be issued on the record. But the key again is unopposed, and what I just heard from SLO's counsel, I think constitutes sufficient opposition that a hearing would need to be set.
Okay, so in that case, do we really need to decide any of the other issues such as the MOU, timing, all of that, or an allocation if we need to have a full hearing?
I would suggest that the commission reserve making that determination until because I would fully expect at this point that this is where, because it's de novo, there is still some ability to put on relevant evidence, and relevant evidence might be considered by let me rephrase that. I'm not applying the rules of evidence, but we've got a nexus here between the substance of the application and then the legalities of an MOU. I would expect that there would probably be some kind of testimony on that to some extent. I don't know what that would necessarily look like, because really what would the parties would be arguing issues of law more than fact, which is a little different for the adjudications for the commission than the norm. So I would encourage the commission to reserve ruling on the MOU issue until the record is complete for the adjudicatory hearing.
Okay, and so, sorry, I'm just stepping through this one piece at a time.
Well,
Okay.
and Madam Chair, the other thing about this is that I've started research on MOUs and how they might impact. This only landed, I think, on our desk a little over a week ago. I'd like to be able to take some time too, and I'm guessing some of the other attorneys would as well, to make sure we understand the actual ramifications, because MOUs have, I see them all the time, but they don't, it's not clear exactly where they're rooted necessarily for their authority in a certain and given situation. So I recognize that we've got the commission has an issue, well, Titus has an issue with the October 1st, but for the sake of making sure this is done correctly and for the edification of future council and commissions, I think there's some value in that, in having that hearing.
Okay. I just have a couple questions then maybe. One, is it on the schedule for October? Is it on the drilling schedule for like literally October 1st, or is it the month of October?
It is currently being drilled. The decision point, yes. Well,
Okay,
they're
not the
drilling
well.
all 4 wells vertically.
Right.
Now, October 1st is the date on which Titus needs to know whether it can drill into Texas or not. So we would request that if there is a need for an evidentiary hearing, and again, I don't think there is, if you want briefing on the MOU question, we're happy to provide that. So we would request that a hearing be set as soon as possible, so that there is still a hope, a possibility that this well could be drilled as planned into Texas. It will prevent waste, and it will protect correlative rights. Now, my client, Mr. Jones, is offering to speak if you think it would be helpful. So with that, I'll stand down.
Okay, so Mr. Moerner, we would basically have to have this the evidentiary hearing before October 1st, right?
That, it sounds like that's what Titus is respectfully requested. If we're to do that, I think with notice requirements, we'd probably do, I mean, it's going to be tough. We'd probably be looking at the last week of the month, but I think if we got notice out properly, we could probably get this scheduled for the 28th. So let me, yeah, that'd be maybe the 20, well, yeah, I think we can get it to 27th. Yeah, 28th, 27th, 28th, 29th. And I would think that the commission would probably not want to necessarily do this on the 30th, and Titus might appreciate that as well. This would also require a really aggressively abbreviated briefing schedule because I anticipate this would generate some significant research and pleadings. So and briefing is always good for the commission, I think. So if we wanted to stick with, yeah, I'd say the 7. So actually it'd be the 28th, and we'd have to, the notice would need to go out tomorrow. And if we're going to do briefing, it would be pretty short term, like 3 or 4 days, and maybe no replies. So like a motion or brief followed by a reply if there was opposition or other thoughts pertaining to it, and then that would be the end of it. I would think the commission would probably want those briefs, the briefing packet done by the 24th. I hate to make attorneys work on weekends because they already do enough as it is, but that's what we'd be looking at.
Okay. And basically what from your interpretation of the rules, we need to have an evidentiary hearing because there is enough opposition.
Yeah, I think that's right. And let me ask this too, though, before we get too deep into the scheduling. Do the parties anticipate any need for any other potential motion practice that might need to be conducted in advance, like before, well, at least briefed before the hearing?
Not from Titus, other than the
Okay.
legal issue that you've raised. And it actually too, we're thinking about what evidence would be necessary at this hearing, because I believe Titus has presented all of the evidence that it would need to present with respect to its request here. And so I'm assuming that this would be an opportunity for the State Land Office to present evidence and for the division to present evidence. Is that your thought on it?
I mean, it could be. I don't assume who's going to put what on anymore with these hearings. But yeah, and it sounds like if nothing else, that the land office might seek to attack the record in some capacity from below and some of your evidence. That's kind of what I mean, I'm not totally sure, but to clarify this, I've heard the land office essentially express opposition, and I'm not totally clear on the particulars of that, which they don't necessarily need to lay out in detail at this point. But if that opposition is enough to stop the commission from being able to just issue an order on the record, because that's what the rule requires, and I specifically use the term, opposition or unopposed, because that's what's in the regulations. So I don't know what I don't know yet, to be frank, not to pull a Rumsfeld on anybody here, but I think that's where I'm stuck, and that's where my concern is.
Well, I'm sorry. I am sorry. I'm sorry.
Oh, no, go ahead. I'm not a commissioner.
Okay, so sounds like we're having a hearing. And I guess, commissioners, I can do the 28th. I cannot do the 27th, the 29th, or 30th. So I don't know what you guys' schedules look like on the 28th.
Madam Chair, may I ask a question, please, Nicholas?
Go ahead.
In communicating with with the oil and gas folks, it looks like I may have missed some information with respect to the timing and procedure here. Now, am I unclear or am I mistaken? Wouldn't Titus availing itself of the offered extension, wouldn't that buy us all time? Wouldn't that solve this problem in the near term, thus affording us all the opportunity to work cooperatively to craft some sort of written agreement between the parties? Wouldn't that allow us to reach out to Texas if need be to see if they have any opinion or stake in the game? It seems that 14 days in COVID times, and I'm not trying to be dramatic, but it just seems extraordinarily difficult to do what we need to do.
Ms. Shaheen, I'll let you answer.
Yes, I'm communicating with my client. My client would like to speak on this issue. Apparently, it's not just a simple extension that Titus has been offered. And so he would like to speak on this issue if that's possible.
Mr. Moender, is there a process for that? I mean, can we?
Hey, so this sounds to me like testimony,
I know.
which I'm a little concerned about because that's not the portion of this case that we're in. And if there is a proposed witness, he would need to be sworn in, and he could be subject to cross-examination. I think that's fair. Because
So
is he gonna is Mr. Jones, right? Did I get the name right?
Yes, yes.
Okay,
And
so is he going to talk? What does he wish to speak about? Because if we're going to get into any substance, effectively of the application, then that sounds like testimony to me. If there's perhaps, even if he's going to discuss the status of the lease extension, I still think that touches on ultimately the substance of the case. So, yeah, my concern is that we're heading into the actual case, and we're going to start getting testimony. And if we're going to do that, then we need to reserve that for the hearing. I'm happy to hear what you know, and I think the commission is, Ms. Sheen, but I'm a little nervous about that.
I
So
understand.
can
And
I
do
think
have-
maybe Ms. Shaheen, if I understand the issue correctly, and maybe you can confirm this, is like the horse is out of the barn at this point because they have already started drilling that 4-well pad, which has this well on said pad. If they hadn't have already started to drill this well pad, then yes, I think that the lease extension, from the sounds of it, and I need you to confirm this, would have given us more time. The problem is that at this point, the 4-well pad, they've started to drill it. And if they don't continue from well 1 to well 2 to well 3 to this is probably well 4 on the schedule, then it's sort of like a use it or lose it in the situation of surface problems that with the spacing on that well pad, you're not going to be able to re-get a rig or completions equipment back in to go back after the fact and complete that well. So is that the situation that we're in, and why a lease extension is not going to buy us more time?
That is correct. And you said that much better than I could have. Thank you.
That's why I got fancy engineering degrees.
I'm glad one
Uh,
of us does. This is Nicholas from the Mexico State Land Office. Can I communicate?
Yes, go ahead.
That I'm reviewing this agenda here, and my understanding of the reading of this thing is this is more of a status conference than the evidentiary hearing, which I think inconsistently the applicant is saying they don't need. We haven't had an opportunity to put up any witnesses. I haven't had an opportunity to prepare for any sort of cross-examination. With respect to, again, to my primary concern, which is timing on this thing, what would a status conference in 2 weeks even be about? Is that tight schedule? Would that, under any set of circumstances, be adequate time to negotiate an MOU, terms of an MOU, or anything like that? And wouldn't an extension solve that whole problem?
So I think, Mr. Kalinsich, that's sort of what I was just trying to confirm with the applicant. The extension is not going to solve that problem because they have already started to drill the pad. And if they do not drill this well while they are drilling, while they have a rig on site on that pad, basically it's that use it or lose it scenario, and the acreage in Texas would be stranded. So
I regret, Madam Commissioner, I don't understand or recognize that position. Forgive me, I'm not an engineer, litigator. I don't understand why they couldn't just do that later. Is it a matter where it can actually be done, but it's going to cost more? I just don't, I regret, I can't
I
speak
cannot
intelligently on
speak
that.
to this specific situation, but I will speak broadly. In general, a lot of times there's limited amount of space on a well pad. And if you have a 4 well pad or an 8 well pad, it is not like you can drill 7 of those wells and then come back at a later time and drill number 8 because of the spacing constraints on the well pad. So if you don't drill all of the pieces of the well pad at once, basically, you drill 7 and then you don't drill number 8, then you're never going to drill number 8 because you can't get the equipment out there in the space that is there because you now have active wells or drilled wells and other pieces on that site. So I can't, that's sort of the big, broad, general, like 40,000 foot view. But it does sound like in general, Mr. Moander, and I think we just need to proceed, is we need to go ahead and get this scheduled because it sounds like we do not have a choice. It sounds as if there is enough opposition that the rules necessitate an evidentiary hearing. And I think it will be a question to the commissioners. One, whether, I think if it's the point of the rule, I don't think we have a lot of choice on scheduling an evidentiary hearing, but I would like to hear both of your feedback on that. And then 2, the timing of it. It sounds like the earliest that it could be done would be the 28th with the noticing requirements. And so first, let's take a step back and commissioners, are we in agreement that there is a need for an evidentiary hearing on this matter?
Is this discussion, Madam Chair, or are you
I think so.
requesting a
They were
motion?
discussing.
Okay.
Is that allowable? Can we just, yeah.
You're absolutely able to discuss, but I'll recommend a roll call vote once discussion is ended.
Yep, understood. Commissioners, any thoughts on the need for an evidentiary hearing?
Madam Chair, Commissioner Warnell here. I could make the 28th work if we do decide to have a hearing. I'm sitting here thinking about this lease that may expire. I'm not so sure that's even an issue in this case because if Titus is out there drilling on the pad, it's my understanding that the lease would not expire. They're out there doing something. So that's my take on the matter. Thank you.
I think it's a waste issue at this point.
The waste
Madam-
issue.
To your point, I think it's a waste. We're I'm sorry, I was agreeing with you. Yes, I think that the lease extension is not going to solve the problem at this point. I mean, we're looking at more of an issue of, is any acreage going to be stranded as they move forward?
And if there was stranded acreage, then that acreage would be in Texas.
Think so.
If I may, it would also be that other 100 feet that we would be drilling and completing up to the state line.
The setback.
Okay, thank you for that clarification.
So
Mr.
Machine,
Baca?
I'm
I'm
sorry,
sorry.
Madam Chair. May I ask a question, Madam Chair?
Go ahead.
So just to clarify it, Machine, so there would be potential waste specifically as to the New Mexico side, because it would not, that 100 feet you just mentioned would not be, for lack of a better term, actualized, I guess, and then that falls within New Mexico. Is that right?
That's correct.
Okay, thank you.
Mr. Baca?
Madam Chair, I am available on the 28th. I think my only thought is what additional evidence would be presented. It sounded like Titus said that they wouldn't be presenting anything, so we would just be hearing from the SLO and if they had any objections. Is that correct?
Mr. Moander, I mean, I think it would be limited to sort of new information, correct?
And
Or-
I would expect there'll be some discussion about the legalities of the MOU, which will come through the briefing cycle as well. Which that I mean, the problem we've got here is we don't know, and I don't think that Mr. Kalinsich is going to be able to tell us what the land office would anticipate putting into evidence. So I think Mr. Baga's description is about half right.
With that being said, I think we can do the hearing on the 28th.
Okay. Is there, I think let's take this in pieces. Is there a motion from one of the commissioners to set or to recommend this for an evidentiary hearing?
So moved.
Is there
Madam
a
Chair,
second?
Commissioner Warnell, I second that motion.
Mr. Moander, would you do a roll call vote, please?
Yes, Madam Chair.
you.
Commissioner Baca,
Yes.
Commissioner Warnell,
Yes.
Madam Chair.
Yes. Do we need to make a
Fantastic.
motion to set the date for it?
Usually with our scheduling, that's not an issue.
Okay.
We'll just set it for the hearing and the notice will go out. And I'll work with Florine on that.
All right. Do we need to set any briefing dates?
I think so, Madam Chair. So looking at the calendar, I'm going to suggest, let's see, 1, 2. We could have motions due on the 21st by 5 o'clock and responses due on the 24th by 5 o'clock and no replies. That would get everyone an opportunity if there's, and this, I think, just to clarify, Madam Chair, I think this should cover essentially any motions. I'm hoping the parties aren't going to bombard with motions that were unanticipated. I trust that won't happen, but we'll leave that. I think we should leave that open just to be sure, since there are a lot of unknown factors here. So that'd be my recommendation.
Do we need to make a motion on those dates? Probably.
Yes, Madam Chair, I would.
Is there a motion to require all motions in this case to be due by the 21st of September at 5, and any responses due on the 24th of September by 5 p.m.?
And no replies, Madam Chair.
And no replies.
So moved.
Thank you. Is there a second?
Madam Chair, I second that motion.
Mr. Moander, would you do a roll call vote again, please?
Happily, Madam Chair. Commissioner Baca,
Yes.
Commissioner Warnell,
Yes.
and Madam Chair.
Yes.
And just for the sake of clarity, this was the evidentiary, the evidentiary hearing and a motion hearing set for the 28th, because if there's motions, the commission probably should hear those first. And what time would the commission like to convene that meeting or that special meeting?
The normal time? 9?
That works. So just asking in case there were any accommodation issues that might need to be
Does
taken
that
into
work
account.
for the commissioners and for you, Mr. Moander?
Works
Works for me, Madam Chair.
Works for me. We'll make it work.
9 a.m. it is. Just going to be spending quality time this month. All right.
I think this is the first special meeting that we've had in a long time, so that's always a good sign.
We got to hear your training. We just had a
That
special
doesn't-
meeting.
That doesn't count.
All right. Are there any other procedural pieces on this that we need to go through, Mr. Moander?
I think we've got everything set. The commission's working to accommodate Titus to see what we can do. I think we're good.
Okay. Great. Well, let's see. With that, if I can pull my agenda up again. We can move on to agenda item number 10. Is there any pending litigation updates, Mr. Moander?
Madam Chair, it looks like a new appeal was filed by Mr. Marker. It A-1-CA 39578. The notice of appeal was filed on 9/8/21. The docketing statement by Mr. Marker would be due, I think it was October 8th, and which would trigger the briefing cycle. This, just speaking broadly, this is a different appeal than we customarily see from this particular appellant. This one focuses on some significant state constitutional questions. So it is a little different. There's a possibility that I may have another attorney in my office handle this, but we will see. But other than that, there is no further update.
Okay. Is there any other business before the commission? All right. Well, with that, our next meeting will be the special hearing on September 28th, followed by the regularly scheduled OCC meeting on October 14th. And with that, it is 11:03 on September 16th, and we will close the meeting for today. Thank you, everybody.
Thank you, Madam Chair.
Thank
We
you,
really
everyone.
appreciate
Thank
the
you.
commission.
Thank you,
Setting the
Madam
bill.
Chair.
Would anyone like to order a copy of this transcript?
Do we need this I think Mr. Moander already dropped. I'm not sure if we need this expedited or not. I don't think so.
Would anybody like, so you would like me to transcribe it?
Yes, please.
Okay, and who shall I send that to?
Um, this is Nicholas speaking for the New Mexico State Land Office. Presumably I'll be sharing it with everyone, but I don't know how your usual procedure goes.
If you send it to Florine Davidson, who's commission clerk, we can make sure it gets out to all the parties and gets in the hearing or the case files.
Thank you very much,
Okay.
Madam Chair. That's Florine Davidson.
Yes, correct.
Florine Davidson, and so all the parties would like a copy of it.
If you send it to Florine Davidson, then she'll make sure that all the parties get it and it goes in the case file.
Okay. Okay, thank you.
Okay,
Thanks.
thanks.
Thank you. Okay, bye-bye.